welcome you again to our Community Development Week, April 10th through the 14th, where we will be celebrating all of the various programs, activities, and services that our CDBG and home investment dollars provide for. We today have another special guest with us as we talk about how do we move from programs to projects to performance. We have Martin Peterson, the City of Waterloo Attorney, that will help us work through some of the challenges that we face when we have legal matters concerning some of the projects, programs, and services we provide. Martin, good morning. How are you doing today?
Good morning, Mr. Jones.
Okay. So we are bringing special guests to bear during this week so folks can understand what does it take to move through what used to be red tape, but now because we're 20, 30 years removed from when we first started 30 years ago, it's not only red tape, it's duct tape, it's gorilla tape, it's masking tape, talking about the different layers that we have to cut through to work through the paperwork to get to an actual project. So we want to talk about how does the legal aspects of our projects play through, especially when we talk about home ownership. There are classes that we have before people are able to buy homes, but sometimes we get lost in the fact that what happens after a home has been occupied 30, 40 years, and now the resident might have to go to a nursing home because of health reasons, because of disability, and we're losing a lot of housing stock because we have not taken into account what the options might be. So if you can kind of give us a very surface level explanation of what a person goes through when they buy a home, and then we can kind of progress through what happens over the next 20, 30, 40 years.
Sure. Title to real estate in Iowa is generally conveyed by a warranty deed, and of course most folks have to have a mortgage on there, which means your bank has a security interest in it. And most spouses hold title as joint tenants. So if you're a joint tenant, once one spouse passes away, the other automatically becomes the owner. In the instances where an individual dies as a single person at an advanced age, if they have not planned in a will or a trust what happens to their property after they pass away, the heirs only have 5 years in Iowa to open up an estate. And if an estate is not opened within 5 years, you can't do it. But the common law in Iowa also says that somebody always owns real estate. So if mom passes away as a single person and doesn't have a will, and the will or the estate is not opened, and in the case of having no will, you can do what's called an administration. If that's not done in 5 years, people still own it, folks still own it, but you can't establish that with a court order. So what I used to do in my private practice is, if somebody passes away and 5 years passes and the estate is never probated, you can fix it, thankfully, under Iowa law. What we used to do is just file an affidavit saying, mom died on this date 6 years ago and had no will. Her estate was not subject to federal estate tax or Iowa inheritance tax, and therefore her 3 children, for example, are now the owners, even if it was never probated or established that way. You can do that. I'm aware that certain folks have Medicaid issues. So if mom went into the nursing home, then the state of Iowa and the federal government wants to be reimbursed upon her death. There are ways to plan for that as well.
So let me interject at this point. When a person comes to community development for an emergency repair, a number of our other services, sometimes we have to help them cut through the red tape of understanding some of these legal procedures and processes, because most of our programs deal with owner occupants. So the first thing we have to do in determining eligibility is establish the legal owner, which speaks to what you just spoke to. And sometimes we avoid the necessity of having legal eyes look at and make sure we make that transference in the most appropriate way so we can have what we call a clean, clean deed, clean title?
Sure.
Because if not, then it means we have to slow down our process and we have to compel some of our tenants, some of our clients, some of our customers to go do such before we can proceed with that actual repair. So you talked about the warranty deed. There's another deed, a quitclaim deed. Explain that a little bit to us.
Well, both convey title to property. Most transactions are done with a warranty deed. And a warranty deed is an antique way of conveying property that basically says, listen, I'm conveying you my property, I'm selling you my house or whatever, and I warrant and defend that I actually own it and there's no other claims. So I convey it to you. It's like buying a car. You say there's a warranty on this thing. A quitclaim deed is basically saying, look, I'm selling this to you. I don't know if I own it or not, but whatever they taught us in law school, whatever I got, I'm giving it to you,
right,
or selling it to you.
Right.
Right? And Iowa law says a school, for example, cannot do a warranty deed. They have to do a quitclaim. So certain government transfers are only by quitclaim deed. So as a practical matter, though, I have not in my 30 some years of being an attorney ever seen an action that's gone back on a warranty deed, because of course,
right,
anytime most folks buy a house, the bank is going to inspect it.
Sure.
They're going to make sure, and there's disclosure forms under
Sure.
Iowa law.
Right.
You got to
Right.
tell them about lead-based paint. You got to tell them about whether the basement
Sure.
leaks.
Sure.
So usually, if there's a problem, they sue under the disclosure forms.
Good, good, good. All of that is very critical and a necessity for our programs to work. What we're also running into, Marty, is in the condition that some of our neighborhoods are in, it's because there are a lot of vacant, sometimes dilapidated, deteriorated, distressed homes that for a multitude of reasons have been neglected. So what we have is this process, this tax sale process, that have these LLCs that will go and buy those tax certificates, and sometimes they might actually invest in the rehabilitation of that home. Sometimes, a lot of times, not. So we're still having those type of structures in our neighborhood. And part of our goal is how do we approach making sure that we get those homes back to a livable condition, but sometimes not, because we have this tax sale transference that the certificate holders don't do anything. Give us a brief overview of what that process looks like and some of the options that we might be able to pursue to keep those houses moved in a livable homeowner's name.
Right. So if I don't pay my tax on my house, it goes into the system of the tax sale. And then the following May, the third Monday, I believe, of May, the following year,
Sure.
is offered for tax sale. And if an entity buys it, out-of-state entity buys it, they have, basically, the owner has 2 years to pay the delinquent taxes. The problem is that the person that buys the tax sale certificate, they get to earn 2% interest per month. That's 24% a year.
Wow.
And that's a lot of money. So the sooner a person can redeem taxes, the better, because it piles up. After they buy it at tax sale, at the expiration of 1 year and 9 months, they can send out a 90-day right of redemption and saying to the person that owns it, look, there's your final notice. You've got 90 days to redeem these, or I have the right to take a tax sale deed. Now what happens is an out-of-state LLC looks at the property and says, boy, do we want to own this or do we not want to own this? Because it's in pretty rough shape. They don't have to send out the 90-day notice of expiration of right of redemption.
Right.
They can just sit on it, and then they never take a deed. And of course, in the interim, the taxes are still owed by the original owner, and so those can go into a tax sale while you're waiting for that 2-year period to expire. So in some instances in our community, the houses we identify as being in pretty rough shape, the tax sale certificate holders have elected not to take a tax sale deed and own the property from the county, but rather just sit there. And they can do that under the current
Sure.
Iowa law.
Sure.
So our remedy as a city is basically to say we're going in on a nuisance action or a 657A action, which under law allows a city to take title to property that's dilapidated and abandoned, and then we can do that. The system isn't really created by anything the city's doing, but rather by the state, tax sale law. It's a tricky issue to sort of navigate.
And what that does, in some cases, it could hold a community hostage until somebody decides to do something proactive to move that house either to a new owner, a demolition process, or a rehabilitation process. And that's a lot of what our end game entail. And that's why it's important that we have this conversation today to begin to have folks to understand we don't want to wait until we have to make some of these decisions. And it's better to address it before it gets multi-layered with all these other things, and you've got family all across the country that you need to get together to make these decisions. Very interesting, very interesting. So what I've recognized on a couple of occasions is missing tax payment might be, a few $100s up to a couple $1,000s. But we've noticed on a couple of occasions where the tax certificate holders will seek to sell that property now because of the process that you mentioned at 3 or 4 times what they may have acquired that tax certificate for, which is, if we could get that property into the hands of someone, an entity before then, those funds can now become part of the rehabilitation, part of the upgrade, versus just profiteering an entity, not because of anything they did wrong, but because of a process we really need to get to the bottom of. So when we talk about things like generational wealth, it would help us to sit down with an attorney, sit down with a finance person, and look at what those options might be to take that 20, 30, 40-year investment and make sure we keep that investment process moving forward versus ending up with a property that's demolished at a negative value, $5,000, $7,000, $10,000, when we could be having that property earn an income for us. What are some of the options that a person could entertain in trying to move a property?
Well, the more planning you can do during your life, the better. For example, if a family is afraid of the state getting all the money from the sale of a house after the remaining mom or dad passes away, there are planning things you can do. For example, what I did in my private practice is mom comes in, she's 68 years old, and she talks to me about having, not to do an estate. Probate is expensive as far as lawyers' fees and attorneys' fees. One tool we used was we would have mom sign a deed to her children and then retain a life estate. And a life estate is an idea that I'm giving you a remainder interest. And the way a life estate works, I'm deeding the property to you, but I'm retaining the right to live here during my life and have all the incidents of ownership. I pay the property taxes, I pay the insurance. I get to own it. Can't really sell it to anybody else because my children are the remainder men, it's called. And the moment I pass away, the folks that I deeded it to as the remainder men, they own it, right? And so the beauty of that is, if you do that 5 years before you pass away, or longer, and then you go into the nursing home, Medicaid has a right for reimbursement. The state has estate recovery rights. However, the system is different when you convey the property and retain a life estate. And so what happens is, if mom conveys it at age 68 and then passes away at age 78, for example, you don't have to pay back 100% of the value of that house because it's a life estate and that has less value. So there are tables, it's called mortality tables, that are used for the inheritance tax calculations. Same system applies. So in the last case I did in my private practice, mom passed away at age 78. We didn't have to pay back 100% of the value of the home. We only had to pay back around 22%. So that's a huge savings, and it allows the family to keep the equity. That's a very, very simple tool that you can use during your life to convey the property and do two things. Avoid the probate process, because the moment you pass away, your children as remaindermen, or anybody as a remainderman for that matter, become the owners. So you avoid probate, and then you also avoid paying back 100% of the value of the home if it was subject to Medicaid, if mom went into the nursing home before she passed away. There are a lot of advantages to doing very simple planning. And there are a manner of more complicated issues to do, because remember, if the estate's not probated, as you've indicated, and 5 years have gone, the heirs or lineal descendants are all the owners of it. And then getting a deed back from all of those folks, if one of them has passed away, you got to go track down their children to get a deed. So it's a messy process. So the more that you can plan during life, the better, and it doesn't have to be that complicated. Of course, you're probably going to have to consult a private lawyer for those things.
Sure. And that's why we have invited you to give our listeners a very surface level sketch of what that looks like, and hopefully encourage them to invest in themselves, invest in their families, invest in their future generational wealth. We're not going to say that these are simple processes, but they're definitely worth considering, knowing that folks have options. So having said that, Martin, again, we want to thank you for coming and sharing that with us, and hopefully that we'll have our those that are listening to take heed to some of that. Call the family together. Call mom, call dad, call whomever, to begin to have these kind of conversations that would make it easier for them before it potentially could get a whole lot more challenging. So having said such, we again thank you for joining in, and it's worth the investment to talk with a private attorney to see what your options are, to help us help you when it comes to being able to provide the services that you might need, being able to keep that generational wealth in your family so we can continue to be the great community that we are. So again, thank you for tuning in. Have a good day.